The purpose of this podcast is to educate and inform. It does not provide legal advice. It does not create an attorney-client relationship. While the host is not a lawyer, the content is overseen by licensed counsel. If you need help with a legal matter, you should always consult with a qualified attorney.
What makes a regulator decide that something deserves a closer look, and what can accidentally make the situation worse? Today on Know Your Regulator, we're getting answers from someone who's been on both sides of the table, inside the FDA as an investigator and attorney, and later representing regulated companies against the agency. I'm your host, Simone Murphy, and today I'm joined by Benjamin England. Benjamin is a former FDA official, microbiologist, and federal regulatory inspector who went on to serve as a special agent with the FDA's Office of Criminal Investigations and an attorney to the FDA's Associate Commissioner for Regulatory Affairs. Now, today he advises companies at the intersection of FDA, customs, and USDA regulations with over 2 decades of experience navigating enforcement, compliance, and cross-border trade issues. He's known for his practical behind-the-scenes insights into how food, drug, device, and cosmetic regulation actually work, and for translating complex regulatory systems into clear, actionable guidance. So today, we are talking about how regulators think, what triggers enforcement, and what professionals need to know before a small problem becomes a much bigger one. Well, Benjamin, thank you so much for joining me today.
Yeah, good to see you, Simone.
Good to see you too. So again, you've had a varied career. Like I've mentioned, you've worked inside the FDA as a microbiologist, criminal investigator, and attorney. And then later you spent decades representing companies against the agency. So how did seeing both sides change the way that you think about regulators and enforcement?
Good question. Most regulators, in my experience, are what I would call true believers. All right. They believe in their mission. They believe in their authority. They believe in the mandate, right, that they get, or it's federal or state. And I've dealt with both. I deal with federal regulators, state regulators, because my clients are in highly regulated spaces: foods, drugs, devices, cosmetics, right. And so the states regulate those products the same way that as the federal government does. But and most of my experience is the regulators, the people that the public interfaces with are. They're not just doing their job, they actually believe in the job they're doing. And that's pretty important because, one, you actually want your regulators to believe in the job they're doing because you want to actually have the effect that the mandate had granted to them by whatever the legislature or Congress. But on the other side, it means that they are going to go into every situation expecting to improve the circumstances, right? Now, most people who are receiving the regulator don't feel like they're being improved upon. Right?
Yeah, right.
They feel like they're being imposed upon, and that's understandable, right? But if there's a good interaction between the regulated and the regulator at that sort of where the two meet in the public inside of the facility after they cross the threshold to do an inspection, or they stop a truck to have a look at what's going on inside the truck, like whatever that interaction is. If that's a smooth interaction, then your regulator is going to be more like your friend. I mean, now they're not your friend, right? So don't make that mistake, right? But there is a greater likelihood that they're going to want to help you comply. And now this isn't universal, right? There are people that have chips on their shoulders. There are people who feel like they've got a badge and or a credential or something, and now they've got power, and that's
right in every industry,
right? And that's true, but I would say that inside, from the inside perspective, the regulator always feels a little nervous going in, just the same way as the regulated feels nervous about them coming in, because they never know how it's going to turn out. They don't know who they're going to confront. So the regulator is going to be trying to get the information they need as quickly as possible, and then sort of get out of there. And if they're made to feel comfortable, then it's going to calm everything down, and it's going to be more smooth, and it's going to, you're going to sort of get through the process more expeditiously. And so that means from the regulated side, which is where I am now, like my job a lot of times is to help the client to understand where the lines are, right? What the investigator or the inspector or the officer is allowed to get, like what they're authorized to get. Versus what they're not, and then help the client figure out what they do or don't want to give, and then how to communicate that in a way that keeps things cool, right?
Yeah,
super important. I'll say that that from being inside and outside, the most important, like those first couple minutes of interaction are the most important thing to keep, the sort of gauges how the rest of the day or the rest of the week is.
Right.
It's super important to have a good first interaction.
Yeah, no, it kind of lays the foundation, like you said, for the future interactions. So, from your experience, when a regulator sees a potential violation, what tends to make something go from, a minor issue to something that is like really serious and becomes a serious enforcement matter?
So in most cases, most regulators have a mandate that has to do with safety
Hmm.
or trust, right? So if you think about it like fraud, right? So so regulators of banks, they're not so worried about whether people are safe when they walk in the bank. They're worried about whether the money's getting ripped off, right? So
Hmm.
that's about trust. So it's either safety or trust. That tends to be the type of things that are important to a regulator. The other thing that's very important to a regulator is documentation, right? If you didn't document it, you didn't do it. It's just that simple, right?
Right.
In their mind, you didn't do it, and they may believe you, but they can't point to anything. So their bosses are going to say, they didn't document it. Now that's the kind of thing. So the two areas I would say are most important is when you're operating in a space where there's a potential safety issue or a trust issue with respect to your industry or your product, and you break that accidentally or otherwise, right? It doesn't have to be intentional, right? Those are the questions, the kinds of things that can cause it to escalate more rapidly.
Yeah.
And so the key of managing your response to that, like identifying steps you can take to correct it as quickly as possible, can help simmer that down and keep it from escalating. And then the second thing is just failing to have a good record keeping system
Hmm.
or failing to maintain it, because that can really hurt you fast. Particularly if you cross the two, right? If they're coming in and there's a safety question or there's a trust question and you don't have documents, right?
Right.
That's going to make it sort of ratchet up relatively quickly. So,
Yeah.
those are probably the two. I'm speaking generally because I don't know sort of what industry people are in, but it tends to be in safety or in trust when you're in it when you're
Mhm.
integrating with the regulator. So that's why I sort of break it out like that.
Yeah, no, and like you said, when it comes down to documentation, if you didn't document it, it didn't happen. Maybe you did do it, but it becomes just that much harder to prove, especially when it comes down to, the mission statement and, the focus of these regulators, which is public safety and
Mhm.
trust. It becomes really, really hard to prove. It becomes very hard to kind of recreate or recall that. So, absolutely. Are there, any other red flags that maybe would make a regulator suspicious or think that there might be more going on here?
Mhm. Sure. I've had clients try to direct an inspection
Oh, yeah.
because they don't want focus in one particular area, so I've had that happen, and that inspectors are. I'll tell you a little secret. I used to train inspectors when I was at the FDA. I was an inspector. I was a trainer for inspectors, and you know I would tell them all the time, particularly new people. Listen, there your job when you walk into the facility is identify what the risks are associated with the product and then find the problem because there is one, right? There without question there's a problem because nobody's perfect, right? And the fact
Mhm.
plus a lot of times there's gray areas, there's interpretation, right? So about whether or not a particular fact is actually representative of a violation, that's a on the spot a decision being made by the inspector and they might write you up for it. It doesn't mean the case is over. I think the key is to not get overly worked up when the inspector finds something. If you think the inspector is
Yeah.
wrong, you speak to it because you want it to be in the record and want it to be in his or her notes. And you may even ask for them to make a note of that. But you don't need to resolve it at the time because you can resolve it later. So I would say getting overly worked up about something can pique their interest, right?
Mhm.
It's like, oh, they're very sensitive about this. Or trying to direct somebody, an inspector, a different direction rather than the direction they were headed. If you don't have a good reason for it, like for instance,
Yeah.
you go that way because you need to have a safety hat on and you don't have one on, like that's a good excuse. But if they start to sense they're being moved and directed,
Mhm.
then they're gonna
Suspicious.
smell. But I the inspector's job is to go in and find the things. The key is really to maintain the relationship, is keep it as calm as possible. But so redirection, another thing that very meticulous inspectors or inspections of records, right, that are a record heavily involving records. Obviously, you got to have the records, and then they need to be organized, right? I like to help my clients develop a system so that, because I know what the inspectors usually are going to look for, and so just put that at the top, right? Just give it to them, because the faster they feel like they got what they needed, the less suspicious they get, and the more likely they get out of your hair, right? So you can. That's how you direct an inspection, is with records, right? You give them the records. I've also had situations where clients have put an inspector in a room and then brought every piece of paper they had and said, there they are, it's in there, right?
Oh man. Yeah.
So that's not a way to, gain friends. But if there are dating issues that are like dates on your records that look like they don't sort of match up, that's going to, without question, raise alarm.
Yeah.
And inspectors are very often they're pretty good at picking up on those things. They're pretty detail oriented. So in your records, details, making sure they're right, giving them the records that are going to be the most important in order to make the inspector's job easier. That they will not suspect. Leading them into a different room when they want to go to that room is probably going to cause them to pay attention, and then reacting a little more a little more strongly than maybe the circumstance warrants is going to make their antenna go up, and they may dig into that.
Yeah, no, all really, kind of, you would think that's a little suspicious if you were to see that, in really any setting. So yeah, no, I can definitely see how regulators would be like, hold on a second there. That's a little suspicious. That's piqued my interest now,
Yeah. In fact, the way I just had this conversation with a client on a litigation matter, and opposing counsel, is really rushing it. They're trying to get a settlement really fast. And I happen to believe it's because their cases are very good and they know it. There's a weakness in their case, right? When people are rushing, that's usually the time when a regulator says, hang on, right?
Yeah.
Right. And then the opposite's true too, right? Slow walking something, it can be the kind of thing that makes a regulator say, it's taken an awful long time to get that record. To me, it ought to be sitting like in that file cabinet right there, based upon what it says there, So, being the extremes are usually the kinds of things that will cause the regulator to do the opposite, right? If you're slow walking it, they're gonna want to try to get you to move faster.
Ask you to pick up the pace.
Yeah.
That makes sense. Yeah. And what do you think that professionals should, understand about respecting the regulator's authority, but not always automatically assuming that the regulator is correct or that they're right?
So this happens with some frequency in my space, just because the statute dictates what an FDA inspector is entitled to have during an inspection, and there are things that are not in that list, and so there will be a lot of times where an inspector from the FDA or other agency will ask to see the customer list, every customer who received a product. Well, okay, they certainly have jurisdiction, because it's federal jurisdiction, right? In the case of FDA, they have jurisdiction over the interstate movement of cargo that's within their jurisdiction, a product in their jurisdiction, so foods, drugs, devices, cosmetics, etc. If there's a question as to whether or not they even belong there, because the product that they're dealing with is maybe not FDA regulated, that's when you have to have an early conversation with the inspector and the inspector's supervisor, sort of protesting the inspection. It doesn't mean that you prevent it necessarily. I mean, you might. First of all, I'd call an attorney before I would do that. If I were you, I wouldn't just tell them to go pound sand, and because they might come back with sand, right? With an inspection warrant, and then what are you going to do? Because it's easy to convince a judge they have jurisdiction. So I would say that the first level is whether they belong there. Let's assume they belong there. The next thing is, are they entitled to the thing they're asking for? And it's important to know where those lines are in your industry with the regulators that are involved. I gave the example of customer lists. Well, FDA is not entitled to customer lists. They are entitled to shipping documents that demonstrates interstate commerce of cargo they have jurisdiction over, right? So they're entitled to the bill of lading, but they're not entitled to my list of customers. And so if I don't want to give them my list of customers because I don't want them to go hunt down my customers and start harassing them, then I would say, well, tell me tell me what you're looking for, and I can give you shipping records or something. Like I find some way to satisfy that and still
Yeah.
keep them within the grounds. If you feel they're going too far, and that happens, first of all, I told inspectors all the time, you could. There's nothing wrong with asking for something you're not entitled to because you might get it. Right. So if you don't ask for it, you definitely won't get it. So you
Hmm.
need to expect inspectors to ask for things that they're not entitled to, and then you have to judge whether or not you should give it to them or not. But if they're not entitled to it and you don't want them to have it, then you got to draw a line. But you do it with them first. And sometimes you need to ask if they can show you the authority where they're entitled to it. And if you're not getting anywhere, then you say, can we put this aside, move on to the next thing, and we'll call the supervisor and we'll have the supervisor help us sort of work it out. And that helps, it
Hmm.
helps show that you're serious about giving what they're supposed to get, that you're protecting your interests, which you're allowed to do. You're not fighting with them. You can move on to the next part of the inspection, right? Keep them occupied, and they're not wasting their time. But you're willing to go over their head in order to get some resolution to it. And
Hmm.
that's how I tell people to handle that, or I handle it myself with them. It's just to make it look. Everybody's doing our job here, right? I think you're limited in yours. You think you're not. So let's get that ironed out. But while we're ironing that out, why don't you come over and sort of you can work on these sections while we're doing that.
Right. Yeah. No, I mean, going back to that, kind of jurisdiction, when a shipment or a product sits kind of at the intersection of two
Mhm.
agencies, who is really calling the shots? And do companies or businesses ever kind of use that ambiguity strategically? Or, does that just end up creating more risk? I think you kind of outlined a little bit of a strategy there, but again, I really want to hear from your perspective, kind of what you see overall.
Yeah, well, so federal and state, that's one line, right? So, and those are different jurisdictions and they have different authorities. A lot of times the federal government will rely on state stop sale authority because FDA doesn't have a very strong equivalent, right? FDA does have, and USDA has a much stronger jurisdiction here, but USDA is actually inside the facility while the plant is operating or the plant's not operating, right?
Hmm.
That's continuous inspection for like meat, poultry, and stuff like that. Um, so that's a little bit, when the inspector's in your facility and the lights aren't on unless he or she is, that's pretty broad
Right.
authority, right? So you're pretty much going to do what they say. But if you take FDA and USDA, FDA has some authority to detain in place cargo if it meets certain criteria with respect to safety and compliance, right? And usually this is reserved for circumstances where the product might cause serious adverse health consequences or death, right? That's sort of like the category.
Hmm.
But FDA doesn't exercise that authority very much because it's very cumbersome and it takes them a while to get it done. And so a lot of times they'll call the state and they'll ask the state to go in, have a look at it. If they agree, then do a stop sale because the state can almost do it like that, right?
Hmm.
And they just issue a stop sale order and that stuff doesn't go anywhere. And then it buys the FDA a little time to do what they have to do on their side, or at least it gets people to the table pretty quickly. Well, in those
Yeah.
circumstances, they both have jurisdiction and you're not going to fight that battle. But you do have it when you have different products, right? So USDA governs meat and FDA does not. But
Hmm.
many facilities use meat in the production of food that's regulated by FDA. And that's where you see those kinds of issues. And the two jurisdictions are not the same. And it's actually governed by the Food Safety Inspection Service under USDA. They're sort of like the sister or the cousin, I guess, of FDA.
Hmm.
But in those circumstances, the jurisdictions are not the same and the reach is not the same. And so there are circumstances where like the wrong inspector is in the room asking for somebody else's data. And that's when you have to say sort of what I just did before, like you do
Hmm.
that same analysis. But you can do it with state issues and federal issues because states a lot of time have more authority than the federal government does. And it's because they have this sort of plenary police power and protection authority over their constituents, which the FDA doesn't. The FDA is a federal agency, so its authority is only granted to it by the people, right? By
Hmm.
Congress. Whereas the states almost can write their own rules when it comes to policing, police power, or public health and safety, as long as it doesn't violate the 14th or Fifth Amendment. Um, but but so they'll have a lot of times more authority at the state level, and And the federal government will leverage that. And that's when you have to sort of watch out, right? If all of a sudden the state shows up about something FDA asked about and they got a stop sale order in their hands, you got cooperation going on, right?
Right.
Agencies talking to each other. And that means they're very, very interested, right? They're not just interested. And so you got to really think about, okay, how far am I willing to push this? What can I do in order to calm this thing down? How do I keep people in their lanes where they belong with the government agencies? And I would use the same kinds of techniques that I would before. Sometimes I get on a phone call with both of the agencies on the phone and say, can someone explain to me whose authority is what? Because I want to make sure I'm talking to the right people about the right thing. It puts them in the spot where now they have to articulate their authority to me rather than me articulating it to them.
No, and that's a great, I don't know, wouldn't necessarily call it strategy, but it's just a great tool to have for when something, you've got agencies that are talking and they're talking about you, get that clarity and make sure, that put the ball in their court for the jurisdiction. Great idea. Absolutely. In your cross-border work, particularly with USDA, have you seen that the real problem isn't necessarily the actual shipment that's in front of people or the product, but it's something about maybe the supplier standing or something that the company didn't even know was a risk? Does that happen very often? And what does the USDA, where do they begin looking for things like that?
So yes, the answer is yes. In fact, it happens a lot, and it happens a lot with FDA. It does happen with USDA. Now, it's less so with USDA, and the reason is that the way the law is written. So I mentioned the fact that USDA inspected facilities or governed facilities in the meat space, meat, poultry inspection. Those agencies, those products are under continuous surveillance because they're being surveilled, like the inspectors in the room when it's being processed. On the import side, it's operated on equivalence. So the foreign government's food safety program for USDA for ag has to be equivalent to the U.S. in order for the USDA to allow that meat to come from that country. So the country is approved, right? And so, but once the country is approved, then of course the facilities have to do registrations and they have to sort of like get into the table, right? Get into the bucket.
Yeah.
Now, but at the USDA, nothing comes into the country unless it's permitted, right? You have to have a permit to bring anything in under USDA jurisdiction, which you have to apply for in advance. So a lot of those questions get resolved at the permit stage, not at the border, right?
Yeah.
In fact, so much so that USDA doesn't even have officials at the border anymore. Or the customs ag inspectors all went under customs under Homeland Security after 9/11. So USDA inspectors are now customs ag inspectors. They wear a customs uniform. Now, they don't know as much, so they're relying intently on the permit. So if the permit, the certificate matches from the foreign government, they're going to let it through. They're not even going to question it. FDA is a little different. The FDA is opposite. Everything comes in unless the FDA has evidence that it appears that it shouldn't, right? Completely opposite. So that means the FDA has to have the evidence to stop it. Now, the way that they do that is that they try to go to the manufacturer for the problem, try to identify a problem that they can pin on the manufacturer so that it's easier to screen at the border. And that's the kind of thing an importer may not find out about until the cargo arrives. I don't even know that it's on the list, right? Or, it's a 25-day voyage from China to the United States, LA, Port of LA, at Long Beach. And while it's on the water, the supplier goes onto the list. Right? And so,
it's got to keep going. Yeah.
Right. If they're not turning it around, right, it's going to hit the port, it's going to get entered, and it's going to get stopped. And so the answer is there's a lot of times. The other thing is that the importers are relying on the foreign supplier to get the labeling right. Right. But the labeling, labels, this is true for state law too, like pet food with AFCO labeling requirements. There's so many things that states have Prop 65 labeling in California. There's so many things that are state-based labeling issues, and they're the easiest violation for the state to find because it's right on the label, right?
Right.
They don't have to test it. They don't have to smell it. They don't have to touch it. They can just go that one, right? And they can stop it and fix it and make you fix it. And so FDA leverages that. So I think that the answer is that there is a lot of circumstances in the FDA space where the foreign supplier has a problem that the importer may not know. And so, but there are ways to research that too. I mean, first of all,
Yeah.
Google uses Gemini, there's Claude, there's ChatGPT, there's all sorts of things out there where you can say, here's the company, are there any flags? Well, you ought to use that,
Right.
I mean, because a lot of that stuff is public. So,
Hmm.
and so there are ways to sort of protect yourself from those kinds of problems.
Yeah, yeah. So doesn't necessarily sound like the USDA is really having too much of that going on. You said that's really resolved at the permit stage. It's more the FDA who, like you said, has kind of that opposite investigation, or not investigation,
Yeah, it's authority
inspection.
authority to stop the cargo, right? So
Yeah.
it's like you never get past customs. And here's
Hmm.
the thing, right? If you're importing something that's subject to USDA permit, that evaluation happens at what's called the manifest level at the entry. And the entry is the importation and the declarations that happen with customs.
Hmm.
So the cargo ship, the vessel or the plane, they have possession of the cargo and they have the right they are not allowed to release the cargo into commerce, right, to the next stage until the
Hmm.
manifest gets released by customs. Well, the question about whether there's a USDA permit or a vet cert that's applicable to the product happens at the manifest level. It isn't
Yeah.
even in the country yet, right? It's sitting at the port, but it's not in commerce. With
Hmm.
FDA, their evaluation always happens after entry. So it's actually in the country. USDA's got it locked down, right? It doesn't even get off the plane unless they
Yeah.
solve the problem,
Yeah.
right? That's because they don't want that stuff in here. And the reason is because USDA is trying to protect American agriculture from meat or poultry or pests or whatever from doing damage to the U.S. agriculture. It's protected, right? It's protecting from viruses and from antibiotic, from bacterial infections or something that could hurt cows or hurt pigs or whatever,
Hmm.
right? They're protecting ag or pests that come in on plants. So they're riding on it's
Yeah.
arriving on pallets. It's arriving in the container, right? That's what they're looking, right? And so whereas with FDA, it's mostly about whether the finished food could be a risk to the person eating it, right? It's not like this
Hmm.
broad impact. It's like it is with USDA. So it makes sense
Yeah.
that they manage that risk at the manifest level instead of entry.
So if someone does get a notice from a regulatory agency, in whether it's an email, a phone call, a records request, maybe, what should they do before they respond? Kind of flipping over to the attorney's side
Sure.
of things now.
Sure. Read it. All right. I mean, read it and make sure you understand the notice. And you got to look for dates because they're always going to have a date. It's going to say you got to respond by X date or this date or that date. I have a client that called me on Monday, had received a Consumer Product Safety Commission inspection notice, actually a notice of violation, and it gave them 5 calendar days.
Oh my gosh.
Received the notice on Friday afternoon. Well, there goes 2 days.
Hmm.
It just disappeared.
Right.
Right. And so we had to address it. And so I got it addressed and I got the cargo release. But it said, it basically was the recommendation was customs should seize the cargo and you should stop sale and you should pull all your inventory of all this product. Well, they sell to Walmart. Right. And so,
Hmm.
so that's a lot of product that's actually already on the shelf.
Yeah.
And, but like the first thing that they pick up on is that 5 days, right? It had a date. You get back to me by August the 12th. Well, that was Wednesday, and we did. So you got to read it. You got to make sure you understand what it's saying. You have to start pulling all your documents related to the product or the shipment or the question or the concern. It could be a notice about a consumer complaint. It could be a notice about a state agency, another state tested product and found it contained salmonella, and you're getting the notice a month later from your home state regulator, right? And now it's
Hmm.
like, geez, that's been on the market for a whole freaking month. I've shipped it 10 times since then, right? So
Yeah.
you gotta think about the impact and start pulling all your documents. You got to follow what it says. It doesn't mean you have to give everything over right away, but you got to understand what they're asking and those things that you can do quickly. You should do. You got to mitigate your own risk, right? You can't sit there and you can't ignore it because one, you have a regulatory obligation to respond, even if the response is that they're wrong, right? You've got to get that in by the time frame. But they're also going to expect you to do things where they can bring some action against you, and then you also have the risk that that there's somebody who could be injured, right? So that
Hmm.
That's true litigation liability risk. And all of these things, right? News gets out about from competitors that you got this notice. That word will fly like that. Right. And then they're calling your customers and saying, hey, do you know so and so got this notice instead of you ought to bring business over my way. Right. So so the key is to read it, understand what it's saying, make sure you get the dates, and then you probably, depending upon your comfort level in dealing with the issue, you may have dealt with it before, deal with it as quickly as you can. But if it's the first time, you might reach out to somebody and get some advice. Like, it doesn't mean they got to handle it,
Yeah.
but you may want to reach out.
Yeah, no, we often see licensed individuals or, companies try and handle it informally or by themselves. And they kind of don't really. No, this is just a different ball game. This isn't Law and Order SVU. It's not criminal court. It's much different, and that could be damaging. We talked about it in the beginning that the beginning of your interaction with your regulator kind of lays that foundation. And wouldn't it be nice if it wasn't even really you interacting with the regulator? It was someone doing it on your behalf. In your experience, when would be that time to kind of really consider getting some legal support, getting legal counsel, or, having someone assist you in handling a notice or a response? And when you choose to get some help, how can that affect your case?
So I imagine that there's sort of like a whole range of viewers, right? So going from small mom and pop shops up to larger facilities that have in-house quality assurance managers, right? Quality.
Hmm.
So it really, in some sense, it's contextual. It depends upon your own experience in dealing with something. There is a tendency, and this is true for state and county regulators, to be a little hometown, right, with the regulated, and that's, it could be legit. It could be that, like, they, that you see them every now and then at the local, Cracker Barrel or something, right? That could
Hmm.
be like real. It also could be that it's a ploy, right? It's designed to lower your defenses and lower your awareness
Right.
so they can get as much information as they possibly can. So you have to watch that out for that as a strategy. It won't work with a larger corporation because the QA manager is going to have SOPs for how do you handle an inspection. And that's the first thing I
Hmm.
would tell anybody. You need to have SOPs, internal SOPs that tell everybody in-house, this is what we do when such and such agency knocks on the door with a notice of inspection, right? If you don't have those SOPs, then it's always going to happen when you're on vacation. It's just always going to happen when you're on vacation. And then you're going to be getting phone calls from the beach, right? And it's going to be this thing, and nobody knows what to do. And now you're doing conference calls and your spouse and your kids are mad at you. And so the way you avoid that is you have SOPs. The SOPs should also dictate if it gets into this area or this area or this area, like a question of whether they have jurisdiction, reach out to counsel, right? Reach out to an outside consultant or
Yeah.
somebody who, if it has to do with anything that has to do with safety or a claim of injury, right? Reach out, right? Those are the kinds of things, because that's going beyond just the inspection. The fact that the inspector makes it feel informal doesn't mean it's informal. Every inspection is formal, and it doesn't matter how informal it feels or how informal the notice period. Oh, they just sent me an email. That's all this is. No, emails are inquiries, and those inquiries are expected to produce a response, which will have a
Right.
regulatory effect. So, the SOP is critical. The degree of enforcement or degree of oversight that the agency has of you. If you're a pharmacy, right, then the state board of pharmacy pretty much owns you, right? So when the pharmacy inspector shows up, yeah, you're going to give them almost everything that they're asking for because they hold your license in their hand,
Right.
right? So that's a much higher risk, and you probably bring in people sooner if it's getting ugly. But a pharmacist probably has dealt with an inspection and probably is okay for as long as
Hmm.
it doesn't go insane. So unfortunately, it's very contextual. It's hard to say. The SOP is
Yeah.
critical, right? And you can get help building an SOP. You don't. That's where I would say you get the help. You get the help before the inspector shows up.
Hmm.
You get the help so that everybody in your facility knows how to handle an inspector showing up, because that's going to help them. Everybody feels more comfortable. You've trained them. Next thing you know, they feel like
Yeah.
they sort of know what to do if the inspector shows up, right? And that's
Right.
key. And then you need to have recall procedures. Like, you need to have SOPs that deal with the safety issues if you're dealing with products. right? If it has to do with renting out equipment or something like that, right? Well, you have to have good SOPs that manage things like how do you ensure the maintenance of the equipment, or what happens if someone calls with an injury related to equipment that you rented.
Hmm.
Those are SOPs, and there should be little trigger points in those SOPs that say reach out to so and so, right?
Yeah.
Well, you want to have so and so help you write the SOPs.
Yeah.
'Cause
So and so needs to be a part of
that
that.
way they know what they're dealing with when they get the phone call. Because then they pull
Right.
up the SOP and they say, "Oh, we're at 4.3. That's a problem," right? And and so everybody sort of is very, very quickly on the same page.
Great advice. Absolutely. And Benjamin, after seeing enforcement on both sides, which is really cool, what would you say is the first step for a professional or a company to put themselves in a stronger position? I know we kind of named it just a second ago, SOP. Anything else that you would recommend?
All right, so the SOPs are critical, and the reason is because the SOPs will also dictate your record keeping procedures. This is one of the reasons why you have it, right? Because and then also ensuring that they're current, right? So you need to have like a SOP. There's like a there are certain provisions that you're going to want to build into your SOPs so that it's being evaluated at a certain period of time to ensure that they're consistent with the law, because laws and
Hmm.
regulations change. Um, and SOPs, the reason you need to have change controls for your SOPs as well. They need to remain current, because if you don't, then what ends up happening is you have laws that change, regulations that change, and you don't have that built into your SOPs, which would be problematic.
Hmm.
So you would need to make certain that you're sort of keeping them constant. But if you have your SOPs, then you can train people in SOPs. You've got something you can point to when the regulator gets there, right? You can say when the regulator says, "Well, what happens? What did you do?" "Well, we followed our SOP, and here it is," right? You give them the SOP. They're reading
Yeah.
the SOPs. Here are the documents to prove I followed the SOP. Now, people say, "I'm small, I shouldn't do that." Well, look, you do have SOPs. You just don't have them written down. I'm just asking you to put it in writing. That's all. And create a little system that makes it a little bit more organized so you could deliver it when you need it to. So those I
Yeah.
think would be the probably the most important things to start with.
Yeah. No, like I said earlier, solid advice. Think it's really great takeaways. Well, thank you very much, Benjamin, for joining me today. Really, the theme that I'm hearing is that knowing your regulator is not just knowing the rules, it's really understanding how the agency is evaluating your conduct, how they are conducting inspections, how responding could affect the situation. And like you said, knowing when you need to slow down and protect yourself and be proactive instead of reactive. Very, very solid advice. So
Yeah.
thanks, Benjamin, for
The way
giving us a good look at that.
And the way I think I close out with this usually is to remember that it doesn't matter what business you're in the business of people. Always, always. And
Yeah.
that's true for regulators. They're in the business of people too. Now they can lose sight of that and get in the business of like enforcement. But if you treat them like you're in the business of people, then you're going to it's more likely you bring them over to your side, even if you're having an argument or a dispute or they didn't like what you did. At least they realize that you're not their enemy. You try to get on the same side of the table on the problem, right?
Yeah.
You're sitting shoulder to shoulder to look at the problem to solve it, rather than sort of confrontationally face to face. And your SOPs, what do they do? They divert, right? They divert. They make it less personal and make it far more about just the thing we're talking about. That's all.
Right.
And it helps diffuse things. It helps them be satisfied that you're serious. So that's why these things are critical, because they help for these very situations that could be otherwise very challenging, can be calmed down pretty quickly if you're prepared for them.
Yeah. Exactly. Yep. All about being proactive. All about just kind of having your ducks in a row. So absolutely. Thanks so much, Benjamin, for joining me today. Appreciate your time.
Great to see you. Thanks so much.
The theme that I'm hearing here is that knowing your regulator is not about just knowing the rules. It's about understanding how an agency evaluates conduct, how your response could affect the situation, and knowing when you need to slow down and protect yourself before making a problem worse. Thank you, Benjamin, for giving us a look at that process from both sides of the table. To our listeners, until next week, stay inspired and continue engaging with your regulatory agency.
Know Your Regulator, the podcast that inspires you to engage.